attacked me, my dad, and when he did, he tried to kill me with a knife, and then it was in Oklahoma, and he died. So,
okay.
Yeah. How was that? I shot him.
Oh my. So there is the young man at the center of a big motions hearing today in Florida. Collin Griffith is accused of murdering his mother. This happened back in September. Now, this was months after he killed his father in self-defense, allegedly self-defense. Kind of makes you wonder now in light of these new charges pertaining to his mom. But his claim with his mom is that she lunged at him, so he says, with a knife during an argument, and that she then fell on that same knife. Police say his story doesn't make sense. Let's go into the courtroom now. His trial is set to start next week, and his attorneys are hashing things out with the judge. What comes in, what stays out? Where we left off, we were looking at some text messages he exchanged with his mother. Makes you wonder, what did she know about his father's killing? Let's go in.
This one is Kathy admitting she went through his text messages, not because she accessed it on his phone, but because she can see them on his MacBook. So I don't know that that resolves the issue at all, because it indicates some subterfuge on her part, not willingly or knowingly allowing her to see otherwise confidential and privileged messages.
I think that's really part and parcel of the condition of my
right.
holding is that, you know, at its core, a child whose parent or guardian or someone acting in love with a parent, his grandparent, whatever, who has some supervisory authority over that child, who has a phone bought and essentially controlled by an adult, that children know these days. Their parents can see what's on their phone or have access and can find ways to access the contents of the phone. So that's really the basis of my ruling. If this phone, and I struggled a little bit with, even if it's not their phone, or the parent's phone, even then, because a parent has supervisory authority over a child, they may still even lack an expectation of privacy in the contents of a phone. That seemed a bridge too far given the juvenile's right to attorney-client privilege. And so that was the basis of my ruling. So that seems to suggest that it could either confirm what the basis of my ruling is that he should have known that she had access.
Although this is a communication between her and her own mother, it's not to Collin. I've gone through the messages.
I understand, but in any event, you understand the basis of my ruling?
Yes.
All right. And the state understands the basis of my ruling?
I do, Judge.
As to the actual proof of the crime fraud exception, recognizing that it's, I think, although it's a little bit unclear, that under Florida law, the state or the proponent of the alleged privileged communication and the one claiming crime fraud would have to establish a prima facie showing that the intent was to get information for the purposes of committing crime or fraud. I think the burden then shifts to the opponent of disclosure to present evidence to refute that, and then it becomes sort of a preponderance of the evidence weighing thing. But it's on the limited information before the court, regardless of the eerie nature of the communication. The court determines by preponderance that the communications were the state has not proved by the preponderance that the communications are excluded because the defendant was seeking advice with the intent to commit a crime. That is not established by the preponderance of the evidence. So the basis of the ruling is that he knew or should have known that the communications would be or could be viewed by another. All right.
And if I,
Yes.
Mr. Arnott, do you have a copy of the text you mentioned?
I only have one copy. Yes.
Thank you.
And this was from your discovery, so
Yeah, thank you. And this is about the mom texting Susan about her reviewing.
her going through how she was able to see his messages on his MacBook.
I appreciate it. Thank you. All right, Judge.
All right. As to the evidence regarding the Oklahoma killing of Mr. Griffith, Charles Griffith, I want to reiterate again, I think that the case law in Florida is ready for clarification in terms of this issue between Williams rule and inextricably intertwined evidence. And when it's Williams rule, does there always have to be similarity, or is that just for identity? But as best I can determine in this case, I am analyzing it under an inextricably intertwined evidence standard because it appears that one of the motives, the evidence suggests that one of the motives for that the state could prove in this case would be exposure for the crime, the killing in Oklahoma, specifically that he had confessed to murder and allegedly that there was Ring doorbell evidence of it, and that this was on the defendant's, a message sent to the defendant close in time. The court wants to reiterate that as to all of the other purposes for which the state has offered it, while it's clear, and there's really no dispute that Mr. Griffith killed his father, there's absolutely been a dispute as to whether it was the result of justifiable use of deadly force. The state has not proven by clear and convincing evidence that the killing was in Oklahoma, that the killing did not result from a justifiable use of deadly force. So that's why I will not allow it for all of the other purposes the state has offered it. So it's the only relevance that the court finds then is motive for the killing of Kathy. I also recognize the highly prejudicial nature of it, of a child who is on trial for allegedly murdering his mother, for evidence to come out that the defendant allegedly, that the defendant killed his father some years ago. So I don't find that it's relevant what the identity of Mr. Griffith is or the relationship. What is relevant is that the defendant was a suspect, person of interest, whatever they're calling him, in the killing of his father in Oklahoma, but that the fact that the alleged victim in that case was his father is not relevant to that. It doesn't matter who it is. It's the fact that he was a suspect and that now his mother is is threatening to expose him as having confessed to it being a murder. So I will allow the state, through those text messages, to present evidence that the defendant, the alleged victim in this case, threatened to expose the defendant as confessing to murder, but will not allow the state, unless the door is opened, will not allow the state to identify Charles Griffith as the deceased, or to establish the nature of the relationship between Mr. Griffith and the deceased in Oklahoma, and also to present evidence that he has yet or has not been charged as of today.
I'm sorry, you will or will not allow evidence that he has not been charged as of today?
I anticipate that that's, I anticipate the state would do that to make sense out of the motive. Mr. Levine, did you have a question?
I did, Your Honor.
So anywhere Mr. Griffith's name appears or is stated in some audio state, whatever that might be, it needs to be taken out. And any reference to him being Collin Griffith's father.
Did you say, was there something in between the last thing and the first thing where you said the state could talk about the relationship between someone and someone?
Yes, the fact that the deceased in Oklahoma is Collin Griffith's father has no bearing on the issue for which the court has found admission of this evidence relevant. The fact is that he was a suspect in a killing of another human being in Oklahoma, whatever, I can't remember the date now, that he has not been charged with that offense. I'm assuming Ms. Thornhill may have developed that some as to reasons why he hasn't been charged. I don't know. But that he hasn't been charged, and then the alleged victim in this case threatened to expose him as having confessed that was a murder. But yeah, the name and the relationship are not relevant to that motive.
And maybe the relationship that
and to the extent that they are, the danger for unfair prejudice substantially outweighs the probative value of knowing who it was and what the relationship was.
When you say the relationship, and not the can't mention that it was the deceased was the defendant's dad, correct, or his name or anything.
Family, just the relationship. I mean, are you wondering whether whether some aspect of the relationship matters? Because if so, let's go ahead and clear that up now. The fact that he has been suspected of murder and not charged, and now has a threat that he's going to be exposed for having confessed to it being a murder, is what's relevant. I fail to see under that limited relevance what the nature of the relationship adds to the mix, whether it's familial, whether it's specifically his father.
So the jury will understand that the defendant was arrested for the crime, but they won't know that the victim or the deceased was his dad or Charles Griffith or anything regarding the name or the relationship, i.e. father-son.
Correct.
Okay.
Unless that door is opened, I don't know if Ms. Thornhill had indicated at the hearing.
This judge has a tough job, doesn't he? So it appears that in these text messages between the defendant and his mother, that she was talking about exposing him for the killing of his father. Now, again, he was initially charged, but those charges were dropped. Investigators deemed it a self-defense incident, and he was never put through the criminal justice system and never went through a trial like he's about to go through next week for allegedly killing his mother. And so now the trial judge has a tough job here, because should the jury know that he killed his father? How should the court handle this? Let's bring in our legal analyst guest. He is the chief trial attorney in the Muskegon County, Michigan District Attorney's Office, Matt Roberts, on the show this morning. Matt, good morning to you. Oh, how might the judge handle this mess?
Well, it sounds like the judge, like you said, has a very tough task here. There's a lot of layers to this, but it sounds like his ruling is essentially that the fact that he had killed his father in some fashion, whether it's self-defense or not, isn't relevant to the fact that it's his father, because the danger there is that the jury would take that to mean, well, if he killed his father, then he probably killed his mother. That's the exact reason you can't use other acts by a defendant against them. You can't just say because they did one bad thing, they did this bad thing. What he is indicating, though, is that if the motive can be established, that the reason he killed his mother is because she was going to expose him for that murder, then it definitely becomes relevant. And then the danger for unfair prejudice is outweighed clearly by the probative value. But tough task, because it's also layered with this argument about the text messages and the prosecution having to establish that there is a basis for them to be able to get to those text messages. So it sounds like he's making a reasoned ruling here. I'm sure the prosecution isn't entirely happy with it, but there's still enough for them to work with as long as they have the evidence.
Yes, yes, great points, Matt. Matt, tell me, as you look at this kid, he's 17 years old, and the allegation is that he murdered his mother, and we know it is a fact that he killed his father. He hasn't been charged with murder at this point for that. We know initially there were some charges, they were dropped. So however that went, it went. But this child allegedly involved with killing both of his parents. What does that make you think? You're a very seasoned prosecutor. You've seen a lot. What does that make you think about Collin Griffith?
Well, it certainly indicates a person with some significant issues, and I'm sure that the Oklahoma authorities at this point are looking with great interest at what's going on in the Florida case, because it could cause them now to go back and re-examine the circumstances here and decide that they can charge this person. Now, it's entirely possible, it's as tragic as it may be, that this is an individual who both of his parents have put him in a situation where he had to use deadly force to defend himself. It stretches the limits of credibility to believe that. It's more likely that there's some trigger with him, some anger issue that is caused by some type of conflict with one or now both of his parents that causes him to act like this. But again, you have to somewhat give him the benefit of the doubt that there might be an explanation for this. It doesn't sound like we're going down the self-defense road in this Florida case, and certainly the circumstances make that more challenging given the evidence in the case that is apparently going to come to light about waiting 2 hours and the crime scene not matching up with any indication that there was any type of struggle. So defense has a tough task here to prove exactly why to make the state prove why he did this, and not necessarily offering an affirmative defense here.
Right. Attorney Matt Roberts, thank you for all of that. Stand by kindly, please. We're going to hit a break. When we return, more of this motions hearing ahead of the trial for 17-year-old homicide defendant Collin Griffith. Thanks for staying with us here on Court TV Live. I'm Julie Grant. So we have a very important hearing happening this morning in Florida for defendant Collin Griffith. So this 17-year-old, we know, already killed his father. It was deemed to be a self-defense case, but in light of the new allegations that he murdered his mother, well, that may be called into question. We will see. Well, the trial over his mother's killing is happening next week. And right now, the judge has some very important decisions to make, because he's deciding ahead of time what evidence comes in, what evidence stays out. And apparently there were text messages between Collin and his mother, Catherine, where she was saying she was going to expose him for the shooting death of his father. Let's go back in.
That case here, I don't know, given my subsequent ruling, whether she intends to do that or to do that as much, but I'm not going to ask her what she intends to do. But if that comes out of the bag, obviously it comes out of the bag.
Now, you mentioned through text. Does that mean that any of the facts of the case or the evidence that I put on at the hearing is admissible, such as body cam footage and/or crime scene photos and/or anything like that?
Mr. Lemine, what is relevant is that he was a suspect, that he hasn't been charged. And I'm talking about in your case in chief. I don't know what Ms. Thornhill is going to do with that. Those things might become relevant. But at the outset of your case in chief, it's the fact that he was, and I don't even remember if they said he was charged.
He wasn't. He was arrested.
Right. So the fact that he was arrested in an incident involving the killing of another human being, and that he hasn't been charged, is what's relevant from that case. The details of it, unless Ms. Thornhill brings them out in an effort to mitigate the prejudicial nature of that evidence, just isn't relevant.
So the actual exhibit or evidence that would represent that would be largely or wholly the text message that Your Honor is allowing, correct?
I'm assuming that the witness to come to court to say there was an investigation and that he was ultimately charged or arrested after the killing took place.
Judge,
What's going on?
this is just off the top of my head, but given the limited nature of your ruling about the state's case in chief, what if, maintaining my objection to any of this coming in, we had a stipulation that fits your ruling, but that doesn't waive my objection, rather than having the state have to bring somebody from Oklahoma in just to say that one thing. I understand in rebuttal, if I've opened the door, then they may be able to call one or more Oklahoma witnesses. I don't know if that's an acceptable option.
That's something that could be considered, although I'm anticipating on calling somebody from Oklahoma. So I'm inclined not to agree to that, but I will consider it and listen to that. But I'm inclined to call someone from Oklahoma to testify for the limited purpose in accordance with Your Honor's ruling. And just so it's crystal clear, the text message is admissible, correct, Your Honor?
Yes, and I should clarify. I mean, I think you can present evidence that the defendant did not dispute that he killed that person. So I would think you would need a witness for that, or if you agree to a stipulation that would need to be included in there.
Is anything about how the killing happened, such as shot the person, so that there could be some context? Otherwise, it might be the jury will be operating in a vacuum, and it'll be very uncertain. The manner, was this just a complete accident? Was it self-defense? I know we're not going to get into the details, but the state would request that the fact that he shot and killed the individual, that should be admissible.
Well, I don't think any of it should be admissible.
Well, I understand.
Yeah, so I think once we start down that path, then it opens the door, just like I can open the door possibly. I think that opens the door to a whole lot more detail that Your Honor was trying to avoid having the jury hear.
Yeah, in some sense, though, it mitigates because it is a dissimilarity from the present case.
And I haven't thought this through, obviously. I'm being presented with the ruling, and
I mean, it's the fact of the killing that is prejudicial.